Hi, my name is Andrew. I'm the founder and owner of Ibis Prep, and as the bar exam is less than a week away, I'd like to share some tips for every subject on the Florida bar exam and on the MBE. I'll go through every single subject, but first I just wanted to give some overall tips and tricks for the bar exam. For the essays, my approach is make it so that the reader cannot fail you. Always write more. Give extra examples. Give extra rule statements. Now remember, timing is a crucial piece of this process, so you can't write too much that you run out of time, but when in doubt, write it out. It's based on a rubric, and the more issues and rules you can spot and the deeper your analysis, the more points you can get. On the MBE, remember every question is an island. Don't ever let a single question previously or subsequently affect the question that you're on right now. Good luck, everyone. Florida civil procedure can be very difficult for students, especially because of the distinctions between federal and Florida civil procedure law. For instance, at federal law, you have 90 days to file a complaint, whereas in Florida, you have 120. Some important terms to distinguish are impleader, intervention, and interpleader. Impleader is when we are trying to bring a party into a case. Intervention is when a party is trying to proactively jump into a case. And interpleader is when we're forcing two defendants to litigate amongst themselves, usually to determine who owns a piece of property. There can be cross-claims, which are claims against co-parties, and counterclaims, which are claims against opposing parties. There are permissive counterclaims, and there are compulsory counterclaims, which arise out of the same transaction or occurrence. Contracts on the MBE can be a very tricky subject. One issue that's commonly tested is the parole evidence rule. We all understand that extrinsic evidence cannot be admitted to contradict a fully integrated contract. However, on the MBE, there are various exceptions to the parole evidence rule that are often tested and will allow the extrinsic evidence to come in and be admissible. One example is a condition to the contract. Another example is to show a defect in formation. Another example is to clarify an ambiguous term or to show custom or trade usage. Finally, a term that adds to the contract but doesn't conflict the contract will also be admissible as an exception to the parole evidence rule. Real property on the MBE is extremely difficult. They love to test mortgages. One area of mortgage law that they love to test is the difference between expressly assuming and taking a mortgage subject to. When the second party takes a mortgage subject to, that means that they are only taking the mortgage as a surety, secondarily liable. The original mortgagor will still remain personally liable for any default on the mortgage. Now, if the new party takes the mortgage and expressly assumes it, then they will become personally liable, and the original party will be the surety or secondarily liable. The only way to get the original mortgagor off the hook completely is to constitute a novation between the parties. My favorite subject on the MBE is torts. One area of torts that is commonly tested is strict liability. There are certain torts that are subject to strict liability, and we should remember that they include wild animals, inherently dangerous activities, and products liability. For wild animals, if it's a snake and it causes someone to trip, that will be strict liability. If it's a goldfish and it squirts at someone, that wouldn't necessarily be strict liability. Inherently dangerous activities. The injury needs to occur as a result of the dangerous propensity, such as the toxicity of the substance and not necessarily its slipperiness. And then for products liability, look for a design defect, a manufacturing defect, a breach of express warranty, failure to warn, or ineffective warning, or the implied warranties of merchantability and fitness for a particular purpose. Con law in the MBE can be very tough. I advise everyone to know the amendments to the Constitution. The First Amendment is your freedom of speech, freedom of religion, freedom of the press, freedom of petition, and freedom of association. Second Amendment is your right to bear arms, and Third Amendment is your right not to have to shelter a soldier during wartime. Fourth Amendment is reasonable expectation of privacy, your right against unreasonable search and seizures. Fifth Amendment is due process, the takings, your Miranda rights, your right against self-incrimination, and your right against double jeopardy. The Sixth Amendment is your right to an attorney after adversarial proceedings have begun, the Confrontation Clause, and your right to a speedy trial. Seventh Amendment is a right to trial by jury at federal law. The Eighth Amendment is right against cruel and unusual punishment. The 10th Amendment is state sovereignty. The 11th Amendment is sovereign immunity. The 13th Amendment freed the slaves, and the 14th Amendment is equal protection. The hardest subject on the MBE is historically civil procedure. And of the subjects tested on the civil procedure part of the exam, students really struggle with claim preclusion and issue preclusion. Issue preclusion is more narrow. It's also known as collateral estoppel, and applies when the issue has actually been litigated and therefore will not be litigated again. Claim preclusion is more broad. It's known as res judicata and is the civil equivalent of double jeopardy. We can't bring the entire claim again. Issue preclusion could be mutual between the same parties or non-mutual if allowed by the jurisdiction, which would be new parties. It's also important to note the difference between offensive and defensive preclusion. Offensive is when you're using it like a sword, and defensive is when you're using it like a shield. Finally, claim preclusion is barred when the defendant wins in the previous litigation, and it merges when the plaintiff wins in the previous litigation. Evidence can be very difficult for students on the MBE, especially hearsay. We know that hearsay is an out-of-court statement proffered into evidence in order to prove the truth of the matter asserted. But make sure before labeling a statement as hearsay that's actually being brought in to prove the truth of the matter asserted and not to show effect on listener or to give notice to the listener. Also, try to distinguish between exceptions and exemptions. A common exemption on the MBE is an admission by a party opponent. An admission is when a party opponent, someone against the other party, says something that is against their interest. But be careful, because a statement against interest is an exception that requires the declarant to be unavailable. Evidence is a subject that a lot of people have trouble with on the MBE, especially hearsay. We know that hearsay is an out-of-court statement proffered into evidence in order to prove the truth of the matter asserted. But sometimes the statement is not coming in to prove the truth of the matter asserted, but to give notice or to show effect on listener. This would be known as non-hearsay. There are also hearsay exemptions. A classic one is a party opponent admission, when an opponent of the party states something that would be against their interest. But be careful, because a party opponent admission is an exemption, whereas a statement against interest is an exception that requires the declarant to be unavailable. An exception where unavailability is immaterial would be an excited utterance, medical records, or business records. So be careful on hearsay on the MBE. Crim Law and Crim Pro actually combine one subject on the MBE. So while other subjects are tested more broadly, it's more narrow criminal procedure and criminal law because the two of them combine to form one subject. When it comes to criminal law, something very important is to distinguish between a specific intent and a general intent crime. Let's think about murder. First-degree murder is specific intent. There's malice aforethought. It's cold-blooded. That means that you need to have the specific intent to murder the person to be convicted of first-degree murder. Whereas other forms of murder, such as intent to inflict great bodily harm that results in a killing, is a general intent crime. If you use a baseball bat to hit someone over the head, but you don't intend to kill them, you could still go down for that type of murder under the theory of general intent. And for Crim Pro, make sure you know the 4th, 5th, and 6th Amendments. When writing a contracts essay on the Florida bar, you can use the same format every time. Buy friends drinks, big drinks. That stands for body of law, formation, defenses, breach, and damages. So body of law is going to be the UCC for goods and the common law for service or land. Formation is offer, acceptance, and consideration. The main defense is a statute of frauds. Contracts for marriage, contracts that cannot be completed with 1 year, contracts for land, executorship, goods over $500, and suretyships. When we see a breach, we need to determine if it's material or immaterial. And we should talk about damages. At contract law, there's legal relief, monetary, and equitable relief, which is court-ordered. The main form of legal relief is expectation damages, and the main form of equitable relief is specific performance. When writing a torts essay on the Florida bar, you should try to identify as many torts as possible. I call it the kitchen sink method. Throw the kitchen sink at the reader. Here's an example. If I walk outside and my neighbor throws a rock at my head and says Ibis prep stinks, I have a lot of potential claims against him. 1, there's assault and battery for throwing the rock and hitting me in the head. 2, there's trespass for the rock intruding my property. 3, there's IID and NIED. Now every time I step outside of my house, I'm totally scared that a flying object is going to come at me. And then another one that you may not have saw is defamation, specifically slander per se, because he said Ibis prep stinks. Well, we remember crimes of moral turpitude, statements about loathsome disease, unchastity, or a person's business are considered slander per se. Con law on the Florida bar can be very tough because it can be either Florida con law, federal con law, or con crim law. When we're talking about Florida law, you want to make sure you understand the homestead exemption. We will protect a homestead within a half acre of a municipality or 160 contiguous acres outside of a municipality from judgment creditors, except for taxes and mortgages, liens, and other encumbrances on the home. We also want to know the sunshine law, which means that all public meetings and conversations must be in the light and there's a public right of access. Federal law, we want to know things like the Commerce Clause, equal protection, and due process. When it comes to con crim, we need to know about 4th, 5th, and 6th Amendment, specifically Miranda rights, the exclusionary clause, and the fruit of the poisonous tree doctrine. Real property on the Florida bar is a very tough subject because there's so many different topics they could test. For example, it could be about easements, and we want to know about express easements, implied easements, easement in gross, easement of pertinent, easement by prescription, and easement by necessity. It could be a landlord-tenant issue, and remember, the landlord has the main duties of habitability and quiet enjoyment. It could be about adverse possession, which requires the elements of open, continuous, exclusive, adverse, notorious, and for the statutory period, which in Florida is 7 years. The statutory period for prescriptive easement in Florida is 20 years. It could also be about mortgages, and a mortgage is a loan that's secured on property, and in the event of a default, they could have a foreclosure action where they'll sell the property and use the proceeds to pay off the senior mortgagee. We have a great mnemonic to use for writing a family law essay, which is JV pieced with a side of mustard. J is for jurisdiction, V is for venue, P is for parenting plan, E is for equitable distribution, A is for alimony, C is for child support, E is for esquire fees, D is for divorce, and M is for modification. Whenever you write a family law essay, you should use the phrase best interest of the child multiple times. When you're thinking about alimony, remember there's certain types of alimony. Pendente light, bridge the gap, rehabilitative, temporary, and durational. We no longer award permanent alimony in Florida. When there is a modification, you're going to petition to the court that had original jurisdiction over the final settlement. Divorces are allowable in Florida when there's been irreconcilable differences or mental incompetence for 3 years. The most commonly tested essay subject on the Florida bar exam is actually ethics and professionalism. And when you're writing your ethics piece, try to stand in the shoes of the most ethical lawyer who's ever lived, and you should decline any representation that even has a tinge of impropriety. Try to recall some of the most important rules of ethics, like the duty of confidentiality, which is even more broad than the attorney-client privilege. Also try to think about conflicts of interest and whether there's a conflict in representing a prospective client due to your relationship with the previous client. If you can take on the representation in good health and good mind, you can do it so long as you get written consent from the client. Now, your firm, if there's a conflict of interest and you're an attorney, you can be screened out so that the conflict won't be imputed. Also, try to remember the duty of decorum, the duty of candor, and the duty of competency. I think of all the subjects on the Florida bar, business entities give students the most trouble because they're lawyers, they're not business people. So I'm going to try to give you a few simple tricks to help you on Florida multiple choice questions. First, let's distinguish between common stock and preferred stock. Common stock has voting rights. We get to vote for the board of directors. We get to vote for fundamental changes such as stock splits, mergers, acquisitions, or changes to the corporate charter. But common stock has junior liquidation priority, which means in the event of a liquidation, preferred stockholders will get paid out first. Preferred stockholders have priority when it comes to dividends. Another thing to note about partnerships and corporations is the different types of entities. A C Corp is subject to double taxation and limited liability, whereas a general partnership is flow-through taxation and unlimited liability. Wills can be a very tough subject on the Florida bar exam, especially if someone dies without a will, known as intestate. If someone dies intestate in Florida, their property will be devised per stirpes, which means everything will be split on the first generational level, and if someone is not there to take, then their heirs will split their percentage of the inheritance. Some things to note about wills in Florida is that a partial revocation is invalid in Florida. We need a complete revocation with intent. Will formalities require 2 attesting witnesses to sign in front of each other. Florida does not recognize holographic wills. And in Florida, we have what's known as the elective share. If you try to write your wife or husband out of the will, they'll be able to take 30% immediately from the estate. Commercial paper is now tested as a multiple choice subject. It's very important that everyone knows what are the elements of negotiability. A negotiable instrument under Article 3 is negotiable if it's a signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time to order a bearer with no additional undertakings. Commercial paper can be a note, which is a 2-party instrument, or a draft, which is a 3-party instrument. It's also important to recognize what is a holder in due course, and that's someone who takes the instrument for value, with good faith, and without notice. Holders in due course are only subject to the real defenses and not the personal defenses. The real defenses are fraud in the factum, alteration, illegality, discharge in court, or suretyship. A secured transaction is when we have a loan that's secured by collateral. Tangible collateral includes consumer goods, farm products, inventory, and equipment. Tangible intangibles are like checks, notes, or drafts. Intangible intangibles would be like patents, IP, or accounts receivable. When we have secured transactions, we have a process of attachment that usually occurs through a security agreement between the parties. We then have the process of perfection, which occurs through the filing of a finance statement. Then we determine priority. A PMSI will have super priority, followed by first in time perfected, second in time perfected, first in time unperfected, and second in time unperfected. Trusts are now tested as a multiple choice subject on the bar exam. In order to create a private trust, we must have a settlor with intent, we must have trustee, we must have trust race, we must have ascertainable beneficiaries, and a valid purpose. There's a lot of different types of trusts. There could be a testamentary trust made upon death. There could be a revocable trust, which is presumed in Florida. There could be an irrevocable trust, we have support trusts, we have inter vivos trusts, which are living trusts, we have discretionary trusts, oral trusts, no contest trusts, which are not valid in Florida, charitable trusts, spendthrift trusts, secret trusts, and semi-secret trusts. A spendthrift trust is created so that outside creditors cannot pierce the corpus of the trust until there's been distribution. Only taxes, alimony, and child support can pierce a spendthrift trust. Criminal procedure can be very difficult for students on the Florida bar exam, especially because of all the dates and understandings of how the process actually works. Usually when someone's arrested, they're arrested via a warrant that establishes probable cause. But when someone is arrested and no probable cause has been established, they are entitled to a non-adversarial probable cause hearing within 48 hours of their arrest, plus 2 potential 24-hour extensions for good cause. If they've been released on their own recognizance and 21 days have passed and they still have not brought charges of probable cause, then they're entitled to an adversarial probable cause hearing. This is very rare, and it's almost like a mini trial to determine probable cause. Some other important dates to note are in regard to speedy trial. If a demand has been made, there's 50 days. If no demand has been made, there's 90 days for a misdemeanor and 175 for a felony. If you're taking the Florida bar exam the day before the MBE, one of the toughest things to do is to keep straight the distinctions between Florida and federal evidence. For example, Florida does not recognize opinion testimony for character evidence, only reputation. Florida also does not recognize the learned treatise doctrine. Another distinction in Florida occurs when it comes to judicial notice. At federal law, we have a must standard for civil cases and a must-may standard for criminal cases. In Florida, it will always be the jury must take judicial notice and they may, but are not required to accept it as conclusive. So in Florida, it will always be a must-may standard. And finally, whereas it's called an excited utterance in federal law, it's known as a spontaneous statement in Florida.